and we will start promptly. Good afternoon, ladies and gentlemen. We're now in public sessions. That agreed? Agreed for Margaret. Can I remind members, witnesses, and indeed myself and members of the media and those in the public gallery to please ensure that mobile phones are switched off for the duration of this meeting, as they do interfere with the broadcast equipment even when it's on silent mode. You're all very welcome to this afternoon session of our Oireachtas hearings, the 7th session that we have in our series of hearings that the Joint Committee will be carrying on over the next 2 days to discuss the implementation of the government decision following the recent publication of the expert group into the matters relating to cases A, B and C versus Ireland. In this regard, I want to welcome to our session this afternoon Professor William Binchy and Honourable Judge Catherine McGuinness. You're both very welcome and thank you for being here this afternoon. Before we commence, can I just remind witnesses, first of all, regarding privilege, that witnesses are protected by absolute privilege in respect of the evidence you are to give to the committee. However, if you are directed by the committee to cease giving evidence in relation to a particular matter and you continue to do so, you are entitled thereafter only to a qualified privilege in respect of evidence. You are directed only evidence connected with such a matter these needs to be given, and you are asked to respect the parliamentary practice, effect that where possible you should not criticise nor make charges against any person or persons or entity by name in such a way as to make him or her identifiable. And members are reminded of the long-standing parliamentary practice or ruling of the Chair to the effect that members should not criticise, comment on or make charges against either a person outside the House or an official either by name in such a way as to make him or her identifiable. Thank you very much indeed. So I now call on Professor Binchy to make his opening remarks. Your pre-prepared remarks have been circulated. Justice McGuinness does not have pre-prepared remarks, so there's no pre-prepared statements for people. So Professor Binchy, you're very welcome and thank you very much.
Well, thank you very much indeed, Chairman. It's an honour, privilege to be here today, and may I congratulate you and the members of the committee on the wonderful job you've done in distilling the complex, challenging arguments on this very humane theme. I'm not going to speak to the paper which I presented for the committee. You can read that obviously in your own time. I really just want to open up on a few points which I'm sure will be involved in our discussion over the next 2 hours. First point I would wish to mention, the rather obvious point, that what we're dealing with here, whatever our perspective may be, is a human rights issue. I've come to this issue and coming to you as certainly a person who believes in the human rights of the unborn. It goes without saying that I believe also, of course, very much in the rights of all those who have been born, and very specifically the mother of an unborn child. I think it's fair to say that yesterday, the evidence which you received and the discussion which developed yesterday was interesting, because essentially what it established broadly, but definitely, was that what's going on in Irish hospitals is wonderful. The doctors in Irish hospitals treat mother and unborn child as two patients. They do their best for both, and they make sure that mothers do not die. That's the wonderful news. We did not hear that doctors are holding back, nervous about intervening, that the law is getting in the way of what they do. On the contrary, the doctors actually said that they do exactly what they would wish to do in order to bring about that result. The net effect of that is that some unborn children do die, regrettably do die. They're not targeted, but if you carry out necessary medical treatment on the mother, the unborn child, in some circumstances, very predictably will die. Also, the outcome is that Ireland is one of the safest places in the world for a woman to be pregnant. All of that we know. So really, what we want, and what I suggest most people in Ireland want, is legal support for the existing actuality on the ground. In other words, the argument which I'm putting forward to you is not a theoretical, abstract, metaphysical argument. It's an argument which really points to the hospitals which are near us here, the maternity hospitals, which are literally one of which is a stone's throw away. You could walk to it in 5 minutes. And what we are asking for is that what they do there every day and every night should have the support of the law. It's a very practical proposal that the present existing medical practice should be given legal support. Now, there's a difficulty in this area, which is that, unfortunately, for the best will in the world, I'm not in any sense denigrating the judges involved, but 20 years ago, without having heard any expert evidence from a psychiatrist at all, the Supreme Court interpreted the amendment, which we have been dealing with for the last 30 years, as actually involving a different legal and medical scenario, which would involve a change in existing medical practice. And what the Supreme Court articulated in that decision would very definitely, if implemented by legislation, would involve a change in legal practice. At the most obvious level, it would involve the carrying out of abortions by obstetricians in circumstances where the woman in question, the pregnant woman, is physically entirely healthy, where the child she's carrying is physically entirely healthy, but in circumstances of suicidal ideation. That is a change in existing medical practice. We heard from the psychiatrists yesterday, again, nuanced differences in views, but we heard from the psychiatrists that they do not regard suicidal ideation as involving abortion as an appropriate treatment. And the evidence that they gave there was striking. So what the proposal is that we should implement the X decision, the Supreme Court decision, in order to change practice, change medical practice, remove the approach of doctors towards treating the treatment of mothers and children as two patients, transforming it by, as it were, involving what are undoubtedly abortions, and also specifically in the context of suicidal ideation, involving abortions in circumstances where they do not take place at present. We then get to what I suppose you could say is the legal and political dimension to this problem, and that is the European Court of Human Rights decision in the ABC decision. That decision is under the European Convention. And thus far, I think it's a point that's worth making, the European Convention has not been interpreted as providing for a right to abortion, a right to liberal abortion. On the contrary, the European Court of Human Rights denied that particular proposition. What they did say in this case, in the ABC case, is that Ireland must clarify its law. In other words, a woman who wants to know what is the situation in my medical circumstances, what are my entitlements, how will the medical practice operate in my context, must have a clear line of understanding in that case. And if she disagrees with what the particular doctor proposes, she must be in a position to be able to look to another doctor. Absolutely reasonable situation. You could make the argument that what was involved in the ABC case was not so much lack of clarity in the existing law, which is absolutely plain, or in the existing medical practice, which, as I say, is carried out in Irish hospitals day and night, but rather an understanding of what that issue was. So what the ABC case is concerned about is the question of clarity in our law. And what the ABC case does not say is that we must introduce the Supreme Court judgment into our law by legislation. I stress that point very strongly, and I do invite the committee not necessarily to believe me on this. You might regard me as a partisan advocate in this area rather than simply a cold legal analyst, but I do ask you to seek the advice of the Attorney General on that point as to whether the ABC judgment requires Ireland to implement the existing framework of law as implemented or as articulated in the X decision, or on the contrary, leaves Ireland to determine its own legal policy in the area towards the protection of the unborn. Undoubtedly, it is the latter of those two propositions. But yet we're being told from many sources, including official sources, that Ireland must, under the ABC decision, implement the European judgment by implementing the Supreme Court decision. That is not a correct statement of law. We then move very much to the political domain, if you will forgive me for treading into your territory. But the government, in circumstances where Fine Gael, prior to the election, made it absolutely plain that it was not going to legislate to implement the Supreme Court decision, the government established an expert group. It established an expert group with terms of reference. Now, that is an act of executive power by the government to establish an expert group with specific terms of reference. And one of those terms of reference, a crucial term, was that the expert group was to put forward options which would be reflected upon by the legislature, obviously, options having regard to constitutional, legal, ethical and medical considerations in the formulation of policy in this area. In other words, the expert group's hands were not tied in any way, nor should they have been, to implementing simply what the Supreme Court said. The expert group was given a broad brief to bring in proposals in the form of options based on constitutional, legal, ethical and medical considerations. Now, there's something very strange in the report, and that is a statement at the beginning of the report that the only brief which the Minister, that's to say the Minister for Health, Mr. Riley, gave the expert group was to bring in options consistent with the existing constitutional framework. That is to say, the constitutional framework as interpreted by the Supreme Court decision. So what we have there is a minister, contrary to the terms of reference which his own government set up this group by, contrary to the promise given by Fine Gael going into this particular election, saying to the committee, briefing the committee, apparently, to bring in options within the scope of the X decision. The government then get the expert group, which has found that its terms have been narrowed by the minister, and they say we must act in the expert group, and here we are talking about legislation. I sincerely request members of the committee to probe the minister in these circumstances, to explain why he briefed the committee in that way, contrary to the terms of reference of the government. It raises serious political issues, but it also raises serious legal issues in terms of going against a committee established in the exercise of executive power by the government. That's an important point. It's absolutely crucial because it has had the effect that the government now say, well, you know, the expert group has come forward with these limited range of options and essentially that sets the tone for debate. It does not set the tone for debate. It is entirely consistent. The Irish people actually formulate policy in this particular area on questions of human rights. The Irish people are perfectly entitled in the exercise of their democratic power to come forward with such protection of the unborn as they wish. Just in my concluding remarks here, I'll actually be shorter than the 10 if that's okay, Minister. I would say, if you want to know the kind of regime that I would like, it is not a theoretical, a metaphysical regime based on lofty academic theory. Rather, I invite you to go down the road 500 yards and ask them what they're doing in that maternity hospital, cross the river and ask them what they're doing in the Rotunda. Ask hospitals. You have already asked them and you've been told by the doctors what they're doing. What we need is legal protection for the existing medical situation, dealing with pregnant women and their unborn children, and also addressing the question of suicidal ideation in the humane way, rather than by terminating the lives of unborn children. I'm sure there will be plenty of questions. I thank you, Chairman.
Thank you. Mr. Justice McGuinness, if you want to sit, and I want to thank you for coming in. I know you had an accident.
Yes, well, it would be easier to sit if the...
If you can get your chair maybe put forward a bit.
Can I use the microphone all right?
No, we can't hear you, so no. If we could get the chair moved forward, please. Thank you, Bernard.
Thank you.
Thank you. It's the sound people, not just you, Deputy.
Oh, sure. Yeah.
Thank you.
Yeah, that's all right. Yeah, you can hear me all right.
Thank you. You're fine now. Thank you very much. And you have 10 minutes,
well,
Mr.
First of all,
Thank
may I thank the House very much indeed for their courtesy in inviting me here. I'm not quite sure why exactly I was chosen, but I'm happy to try and be of as much assistance to the committee as I possibly can. As you can see, I have suffered an accident and I've been relatively ill for the last few weeks, so that I haven't had the opportunity to prepare an opening statement and an introductory statement. But there are a couple of things that I would just like to stress at the beginning. First of all, I am not representing the judiciary in any way. As you know, I retired from the judiciary in November 2006, and I'm also retired from the Law Reform Commission. And as some of you know well, I've been recently heavily involved in other issues, as you know, leading up to the 10th of November last. I also noted that I was described on the radio, even at lunchtime, as being someone who would hold more liberal views than Professor Binchy. Well, I don't actually think that my views are relevant at all to this. I am here as a lawyer, and I want to talk about the law, and I am not trying to put forward my views or anybody else's views. I just want to make my own position clear as far as the law is concerned. I know that Professor Binchy has made many criticisms of the X judgment. I reread the entire judgment last night, and I would have a different opinion of it, in that I feel that the court made a genuine effort to reach the huge human dilemma that was put before it, rather than simply approaching the thing from a theoretical point of view. I think that they made excellent arguments with regard to the way in which the Constitution should be interpreted in a traditional way, following the previous judgments of Mr. Justice Walsh, who is recognised as being our most prominent constitutional judge, as it were, bringing together the 1983 amendment part of the Constitution with the Article 41 part of the Constitution, which talks about the important role of the mother in the home and her position as a woman in the constitutional family. So that, but again, I don't really think that either Professor Binchy's views of the judgment or my views of the judgment are really relevant to what you have to do, because the Supreme Court reached its decision in the X case. It is an authoritative interpretation of the wording of the 1983 amendment. There have been other cases since, some of them not very well known because they were held in camera, but this interpretation stands. Two further referendum proposed changes in the formula to exclude self-destruction. They failed. Many people will say people voted for this reason and that reason. We do not know what reason people voted. The ballot box is secret. The X case judgment stands and is the law of this country. It is an outline. Legislation is needed for more detail. And this is what was re-emphasized in the A, B, and C case. I don't really think that the A, B, and C case went into details of what it was. They were emphasizing that the law was there, but that it needed, as Professor Binchy also says, clarification. The government now proposes to take this long-delayed step, and I consider that they are correct in law in so doing. As it happens, I also believe that they are right in using outline legislation and regulations to achieve this end. And the reason I feel that is because I saw what has happened with the divorce legislation, that all the detail of the reasons for divorce and so on have been brought into the Constitution, thus making it impossible to reform them in any way without a referendum. I think that your approach is right. Implied in this, of course, is the need to change the criminal law, the fact that we are working on an act that was passed in 1861. If you even read it, you realize how odd the phraseology is and how difficult it is as being a sword of Damocles held over the medical profession. Again, I'm not going to go into argument about the medical evidence that was before you. You have that evidence before you. I'm not a medical expert. I'm not qualified to comment on it. You have heard it. Perhaps I should say, as most of you also know, I'm a practicing member of the Church of Ireland. The Church of Ireland doesn't necessarily exact from its members unquestioning obedience to statements of the House of Bishops, or by the Standing Committee of the General Synod. However, I should say that I'm largely in agreement with the position taken by the Church of Ireland in its statements on this subject. But of course, again, you will hear that in more detail tomorrow. I've no desire to enter into aggressive debate about this, and I know that with Dr. Binchy here that he will not be an aggressive debater in that sense either. But I do believe that I reflect the views of a large number of Irish men and women who are kind of holding the middle ground on these views, who don't feel that one particular position is absolutely right and we should all run along with that, or that the other position is absolutely right and that we should all run along with that. Professor Binchy has talked about what we need is legal support for the actuality on the ground. Now, I just want to look at the actuality on the ground as it really is, not just in the sort of perhaps esoteric conditions of the maternity hospitals alone. Of course, what he says about the maternity hospitals is perfectly right. But he is completely forgetting the thousands of Irish women who travel abroad for abortions. To say that we have no abortion in Ireland is simply not true. We have abortion in Ireland, we just have it elsewhere. And in a sense, I think that what we have done in the 1983 amendment, we have looked at an ideal situation. We have said we don't, 2 more minutes, we have said we don't want abortion, but on the other hand, we really want an escape route from that as well. We voted, as soon as the X case was over, we voted for the right to travel and the right to information. Why did we do that if it was not that we wanted an escape route from the absolute? The reason you have got the suicidal ground introduced is because we insist on saying it must be a risk to life only and not a risk to health. If you allowed to say that in the case of a 14-year-old who had been sexually abused and raped, that she could have an abortion because of that reason, rather than saying you must show a threat to life. You see, the suicide, it does create difficulties. I can see that it creates difficulties for you, but it creates difficulties because you insist on having only the life ground. And therefore, personally, I think that at the moment, you are legally bound to stick with the X case as it is. If you want to change it, you're going to have a referendum. And even Dr. Binchy more or less acknowledged that this morning on Morning Ireland. If you want to change that, if you want to get rid of the suicide ground, the Constitution says the Supreme Court has to interpret the law. It has interpreted the law. You're stuck with it, I think. And perhaps I'm prejudiced as being a past member of the court, but I think I'm constitutionally correct. Thank you.
Okay, thank you. And Mr. Binchy, in terms of the minister, as you know, per page 8 of the expert review group, the only brief that the minister gave the group was to deal with the requirements of European Court of Human Rights judgment and to advise the government on how to give effect to existing constitutional provisions, just to put that in the record.
Third part, Chairman.
Yeah, okay.
Existing constitutional provisions.
Okay. So 60 minutes for the members of the committee, and I'll take Deputy Keller first, please. Deputy, 3 minutes.
Thanks very much, Chair. Just to welcome the 2 witnesses here. I suppose at the outset, to refer just to Justice Catherine McGuinness, I mean, it was the Irish people decided in 1983 that was the life of the mother as opposed to the health. And subsequently, the X case has introduced the issue of suicide. Now, we've had expert witnesses in here in the last number of days, coming from different views, some pro-choice and some pro-life, some you could contest middle ground, and just trying to address with what is facing us as a legislator in trying to address this very sensitive issue. Now, there's two key points here, and I think we certainly want to get clarity on this particular issue. And I think it is important that we would raise the issue of suicide ideation. And clearly the psychiatrists and expert groups yesterday said that there are varying forms of suicide ideation. For you, suicide ideation, you have suicidal intent, and you actually have a position where a woman could carry out suicide to its finality. But equally, they also pointed out that it is only in the event of a woman being suicidal because of the pregnancy that a termination could lawfully be carried out. That is what the experts are saying. Now, equally at the same time, Professor Binchy, we did have masters of the various rotunda, but particularly Dr. Rona O'Mahony, who said quite clearly she wanted to be guaranteed that at no stage would she be threatened with jail, or the patient would be threatened with a criminal conviction in her carrying out her duties to protect the life of the mother. And I think that's a very, quite profound statement, and it certainly resonated with a lot of people. But equally at the same time, you are right. Many people in all sides of this House and in broader society have strong views on the issue of suicide. And are you saying quite clearly that we don't need any form of legislation, that the present structure as is sufficient? Or are you saying that we need a referendum to address the issue of suicide? Well, it may be suitable to you in terms of deleting that particular provision, but are you saying clearly that a referendum is essential in addressing this particular issue? Or could it be addressed in legislation exempting suicide under the present constitution?
Thank you. Deputy O'Quillan. Thank you, Deputy.
I join with you in welcoming both Professor Binchy and Justice McGuinness. If I could ask in reverse order, if it's possible, Justice McGuinness, just appreciating...
I think we'll take blocks of 4 questions together first and then I'll come back to you. Sorry, Deputy.
Mindful of the fact, Justice McGuinness, that you are retired from practicing, I nevertheless would like you to advise us if it is your understanding that the existing law provides for interventions in the circumstance that has just been described by my colleague, where there is a risk to the life of the expectant woman as a result of suicide allied to her pregnancy. It is the view of some who have come before us, and it's provided for indeed in the guidelines of the Medical Council, that that is a current understanding. And I just ask if you could shed any further light on that in terms of your understanding of it. Professor Binchy, I'd just like to focus on 2 particular points. And they both come from your submission, but you've alluded to them in your oral presentation here this afternoon. You state on page 2 that if the Oireachtas proceeds, as it now proposes to do, that as in many other instances, in fact most other countries, you state, that the law on abortion would change with further extensions being demanded. Now, surely it's only the Irish people who could make such changes. The constitutional protections remain in place and no change can occur that is in conflict with any article or subsections of the Constitution without the express consent of the electorate in a referendum. And if the Chair would just allow me just to finish my second point. You quite rightly reflect on the high standards in our maternity hospitals. And we heard yesterday the excellent contributions of the Master of the National Maternity Hospital, the Master of the Rotunda Hospital, and Dr. McCaffrey in Kerry General. Why do you suggest, and it is a suggestion because it's not a bold statement, that that situation would change? That situation would change on the introduction of the proposed legislation. I have it to say, and I just conclude with this comment, the people who came before me yesterday and my colleagues in this committee came across as exceptionally caring, compassionate and dedicated professionals, and I would have every confidence that that is exactly as they would continue to perform.
Thank you. Deputy Healy. Thank you, Deputy.
Margaret, just to welcome the witnesses and to thank them for their submissions. And I just want to start again with a question I've asked previous legal witnesses, if they would give us their understanding of the current legal situation in this area. What is your understanding of the current legal situation in this area? I think Professor Binchy says that the people set the policy. We've had a referendum in 1983, and we've had 2 subsequent referendums in relation to this area, 92 and 2002. And I take it that is the people setting policy in relation to this particular topic. And I just wonder, as that is the case, and in view of the fact that the vast majority, if not all, the medical people and certainly all the obstetrical people that have been before us have sought clarity, legal clarity in this area. Could I ask Professor Binchy, what is his suggestion on that basis? We've had the various referendums. We have the medical people, and particularly the obstetricians, saying they need clarification. So what is Professor Binchy indicating or suggesting that this Oireachtas should do in relation to the issue.
Thank you, Deputy. And finally, in this segment, Deputy Ciara Conlon, last Ciara.
Gurmagat, and to thank our two speakers for their presentations. I just have a number of questions. Firstly, for Professor Binchy. Throughout your statement, you referred to the Supreme Court decision as discredited. And I'd like to know on what basis are you using that kind of language? Because as I understand it, the Supreme Court is just that. It's the Supreme Court of the land, and their decision is the law. And it is now our job, and I would, as a legislator, admit to the fact that there has been a failure to legislate for the last 20 years in this regard. But I would like to know why you have said that it is discredited Supreme Court decision. And I also understand, with all due respect, that you're invited here as a constitutional expert and not to give political or personal conjecture on this issue. And I would just like to make that point. In relation to another point that maybe that I would put this point to Justice McGuinness in relation to consent. It's an issue that I've spoken about before, and in light of the children's rights referendum that has been passed, that we, again referring back to the X case, and that we have a 14-year-old child, and also to the case and the plight of children in care. And what we need to do as legislators to ensure that their rights are vindicated, to have appropriate medical treatment if so required. I'd welcome some feedback on that.
Okay. And it should be pointed out that Professor Binchy is here as an eminent academic as well. Professor Binchy, you want to start first?
Okay, well, perhaps I may finish up by coalescing a couple of points rather than just reiterating what I
And we
said
have
before.
5 other people who've indicated as well, so thank you.
Okay, just picking up the last point first, perhaps the point of concern expressed there about the political character of what I mentioned. I think that's important because it links very strongly into the legal dimension. Because unless we understand, and unless the Irish people understand, and unless the politicians understand that it is not necessary under the 18th to actually implement the Supreme Court decision. That's a crucially important legal point. And sadly, as I say, the expert group found that its terms of reference, which were broad, were narrowed by the Minister. That is crucially impacting on the legal solutions that are now before the committee at this stage. So I would definitely regard that as a legal issue. The point was raised, well, how do we proceed in this area? Supreme Court, how is it discredited? Well, if it's discredited by a number of commentators who wrote about it, I would be hard-pressed to think of any commentator who unambiguously welcomed its analysis and said that it was right in every respect. Commentators whose viewpoints would not be the same as mine, who would be neutral on the issue of the whole question of abortion or perhaps pro-choice, a number of those commentators expressed a critique of the Supreme Court adjudication process at the time. I'm happy to name one or two if you so desire, just to give substance to that. It's true also to say that the facts are fairly obvious, that the Supreme Court, in the 1992 decision, heard no evidence from any psychiatrist. And I think it's fair to say that in circumstances where a proposal to introduce into our law a ground for abortion based on suicidal ideation without having heard the evidence of any psychiatrist, I don't think it's unfair to describe that decision as worthy of criticism in the circumstances. As regards where we move, reference is made to the children's referendum, and just shows, law is meant to be. You see, law has got no values within its own system except a few values, very important values, like treating everybody fairly and equally. That, I think, would be regarded as a distinctive legal value. Hearing both sides of the case, that's a distinctive legal process value, which is important. But beyond that, law is a scaffolding into which or on which one builds a building or around which one builds a building. And the building that one builds, that society builds, is based on the values that society wish to see incorporated in law. Law does not tell society what that building should look like. The values which are infused into law are the product of social choice, not of the legal system itself. That's a crucially important point. And in that context, the children's referendum, which was passed just a couple of months ago, the first line of the children's referendum says that the state recognises the natural and imprescriptible rights of all children, all children. And I will raise a point, not that I think it would necessarily succeed before the existing Supreme Court at this moment, but it does raise a question of constitutional interpretation. All children, Who are all children? Do they include only children who have been born just after the 40 weeks of gestation? Or does the constitutional referendum embrace what the language on the face of it seems to do, its respect and acknowledgement of the inalienable and inherent and natural rights of all children? Well, I think the short answer that many lawyers would give is, well, you know, the Supreme Court was talking about the pro-life amendment, which defines children in terms of the unborn. Not children, but the unborn. But if one goes, as Judge McGuinness did last night, more recently I just went through the X decision again, the Supreme Court decision again, and there are 40 references to unborn children in that decision. The Supreme Court had no difficulty referring to unborn children as children, even while interpreting the amendment in question. And that raises a question for constitutional interpretation now. The most recent time the Irish people have spoken is in the children's referendum, and they have given respect to the rights of all children. Do I suspect that this argument would be successful in convincing the Supreme Court that that impacts on unborn children? I frankly have to say I would not make that confident prediction. But it is interesting from a legal point of view that one has to look at text, one has to interpret it. Supreme Court has that task at all stages, and we have a new constitutional textual situation applying to all children at this moment. It's fair to say, I think, true, that the Supreme Court has come up with some surprising decisions, not just the X decision, but the manner of analysis that the Supreme Court came up with in the question dealing with not entirely unrelated area, which is the embryos, not before you now, and I assure you I'm not going to bring you down that path in my remarks now. But it is important that the Supreme Court found that there was no constitutional protection whatsoever for embryos outside the womb. Surprising decision, I think it would be fair to say, not necessarily consistent with the wider democratic views on this matter. So when one is asked, do we accept the Supreme Court because it is the authoritative voice of interpretation of the court, one accepts, of course, the legitimacy of the Supreme Court to interpret the Constitution. I'm not suggesting for a moment that Judge McGuinness, when she was on the court, in fact, my own personal view about Judge McGuinness is that she contributed wonderfully to Irish jurisprudence. But I give her that compliment not just because she was a Supreme Court judge, but because the quality of her analysis and the quality of her judgments were perfectly free to respond to a Supreme Court decision and, in certain cases, say the Supreme Court got it wrong. And that can lead, in many cases it does lead, to a constitutional change. There's nothing unusual about that. That is part of what a democracy consists of.
Ms. Justice McGuinness, 5 minutes.
Thank you. I'm trying to, there's 4 questions here, and I'll try as quickly as I can to reply to as much as I can. To be quite honest with you, I am not... I would not say, as kind of handed down on tablets of stone, that when you talk about a risk to life as a result of suicide related to her pregnancy, as opposed to suicide unrelated to her pregnancy, I just don't think that question has been put before the courts and has not yet been decided. And this is something that is a difficulty that people often have. They say, well, the courts ought to have said this or that, but the courts decide precisely what's put before them, just as the Supreme Court did not decide that you could have abortion up to 9 months. They were not asked to decide on a time limit. A time limit would be a thing for legislation, and the people who attack them about that, I think, are completely wrong. You can get things not decided. I'm sure you've heard other lawyers who perhaps would be more prepared to guess on this, as it were, but I don't think I am prepared to guess on it. I think when you talk about looking at the current legal situation in this area, that you have to look at the whole current legal legislation, legal position, the position set up by the various referenda, the referenda that in 1992 and 2002 that rejected a very clear attempt to do away with the suicidal ground, the self-destruction ground that was put specifically to the people. And for whatever reason they voted against it, they voted against it. And if you're going to say that the referendum is the ultimate democracy, well, then it is the ultimate democracy. Again, they voted for a right to travel and a right to information. And we would be naive if we thought that that was not a recognition that people do go abroad for abortions. And therefore, I think when you're looking at the views of the Irish people on this whole issue, you should look at all the people who don't write to you, the people who don't have robot telephone calls bothering you in your offices, the people who are there sort of saying, well, I don't really want abortion, but if it was my daughter that was a 14-year-old that was raped, but if it was, if the human dilemma is put before them, they're out on the streets about the X case, they're out on the streets about Savita. So that people are not quite, they're more subtle than saying, this is our ideal and come hell or high water, we're going to stick to it. So as regard to discredited decision, well, it's a matter of opinion whether you discredit it or not. And with regard to the psychiatrists, yes, I think it would have been preferable perhaps to have a psychiatrist, but there was a very well-known psychologist. And in fact, another well-known psychologist that was at a meeting I attended this morning of the Children's Rights Alliance did say to me that she felt it was a great pity that there was no psychologist present for giving evidence in front of the committee, that it was all psychiatrists, and that psychologists had a lot to say on this as well. And with regard to the children in care, it is to be hoped that by the more detailed guidelines and the more detailed regulations that are to be made, that the situation of children in care will be taken into account, and this would be in accordance with the children's referendum. Of course, I agree with Professor Binchy about the importance of the children's referendum. I wouldn't I, as the famous saying is. But I am rather interested that among the people who most strongly opposed the enactment of the children's referendum were in fact the same people who are extremely, much more violently than Professor Binchy, against any possible move on introducing abortion. So that I found that a little strange, that you're terribly for the rights of the unborn, but when you come to the rights of the born, you're not so enthusiastic. So, I really do think that you need to look at the middle ground, at the middle people of Ireland who don't keep after you all the time.
Okay, Senator, now we've got 7 members who want to speak, and there's a half an hour on the slot remaining, so if members could be precise and concise, please. Senator Burke.
Professor Binchy, in the expert report, group report, in the preface written by Justice Sean Ryan, he says, the European Court of Human Rights concluded that there is an existing constitutional right which was identified by the Supreme Court in the X case decision, and it is logical and rational that the right should be available and enforceable. There should be a formal, accessible, transparent procedure, and Article 47 of the Convention requires implementation of the Strasbourg judgment. Are you suggesting that Justice Sean Ryan was wrong in saying that? Because that seems to be what you were saying in your submission. And the second issue that I have is in relation to your submission here. You were saying, if the Oireachtas proceeds on the basis that it is permissible intentionally to terminate lives of unborn human beings, what principled barrier is there in extending the circumstances to which lives may be terminated? Isn't Article 40, Section 3, subsection 3, that protection, in the sense that it says that the lives of the unborn are written into the Constitution and protected, and that same protection isn't in the constitutions of other countries? So it's wrong to do a comparison with other countries in that respect as regards broadening the right.
Thank you, Senator. Deputy Dennis Naughton.
Thank you, Chairman. Can I thank both of the speakers? I think both of them are very articulate and impressive speakers that we've had here this afternoon. Just a couple of brief questions to Professor Binchy. You made the point in your initial presentation that you want to give legal protection to the existing medical practice, and you outlined the evidence that has been given yesterday here. Now, the Medical Council, in their presentation yesterday morning, made it quite clear that suicidal ideation is already part of their guidelines. The perinatal psychiatrists that were before us here yesterday believe that they're competent and confident to deal with any such case that should come before them. No case has come before them at present. So are you saying that the existing situation in relation to suicidal ideation as practiced under the Medical Council guidelines and the perinatal psychiatrists is adequate, or that should be changed? Secondly, can I ask you in relation to the Medical Council ethical guidelines? My understanding, correct me if I'm wrong, because I couldn't get an answer from the Medical Council,